हेलो गाइस एंड वेलकम बैक टू माय चैनल। आज जिस टॉपिक से हम स्टार्ट करने वाले हैं दैट इज चैप्टर 12 ऑफ क्रिमिनल प्रोसीजर कोड, इन्फॉर्मेशन टू पुलिस एंड देयर पास टू इन्वेस्टिगेट। आज हम सिर्फ सेक्शन 154 पढ़ेंगे विच इज़ अ वेरी 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 इंपॉर्टेंट सेक्शन। आपके क्लास के एग्ज़ाम्स, अगर आपके सेमेस्टर एग्ज़ाम्स है उसमें भी पूछा जाएगा आपसे, प्रीलिम्स का कोई एग्ज़ाम है उसमें पूछा जाएगा, मेंस का कोई एग्ज़ाम है। इट इज़ अ सेक्शन जो आप सबसे ज़्यादा आपके कोर्ट्स में काम आता है, विच इज़ अ वेरी 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 इंपॉर्टेंट सेक्शन। इस सेक्शन में हम FIR के बारे में पढ़ेंगे। FIR फर्स्ट इंफॉर्मेशन रिपोर्ट इट्स एन अब्रीविएशन फॉर फर्स्ट इंफॉर्मेशन रिपोर्ट। एंड FIR हमेशा सिर्फ कॉग्निजेबल ऑफेंसेस के रिलेटेड होता है, इट इज़ ओनली विद रिस्पेक्ट टू द कमीशन ऑफ कॉग्निजेबल ऑफेंसेस। FIR टर्म न कहीं CrPC में यूज़ हुई है, न it has neither been defined in either CrPC और Indian Penal Code। ये कहीं पे ना डिफाइंड है या इसकी CrPC या IPC में कहीं पे भी कोई डेफिनेशन नहीं दी गई है। ठीक है, अब FIR लॉन्च कौन कर सकता है? अब तो आपको पता है कि इट्स फर्स्ट इंफॉर्मेशन रिपोर्ट। कोई भी ऑफेंस अगर हुआ तो उस ऑफेंस के रिलेटेड सबसे पहली जो इंफॉर्मेशन जाएगी पुलिस ऑफिसर के पास, तो उसको हम बोलते हैं FIR। एंड जस्ट इन केस देयर इज एन रिफ्यूज़ल तो मैजिस्ट्रेट के पास जाएगी इफ देयर इज अ रिफ्यूज़ल टू लॉन्च एन FIR आइदर ऑन बिहाफ ऑफ पुलिस ऑफिसर इन चार्ज ऑफ अ पुलिस स्टेशन और द सुपरिंटेंडेंट ऑफ पुलिस। ठीक है, तो जो ये FIR है ये लॉन्च कौन कर सकता है? नंबर 1, या तो विक्टिम हु इज़, जिसके साथ कुछ हुआ है। दूसरा, विटनेस, जिसने देखा है कोई ऑफेंस होते हुए। या तीसरा, someone else with the knowledge, I'll write it here, with the knowledge of crime। तो ये तीन लोग ऐसे हैं who can lodge an FIR। ठीक है, सेक्शन 154, जैसे मैंने आपको बोला, अगर आप उसकी हेडिंग पढ़ोगे तो सेक्शन 154 में सबसे पहले द टर्म दैट हैज़ बीन यूज्ड इज कॉग्निजेबल ऑफेंसेस। तो हम FIR किन केसेस में लॉन्च करते हैं? ओनली इन कॉग्निजेबल ऑफेंसेस। ठीक है, बिफोर गोइंग इनटू द वेयर प्रोविजन, हम पहले एक केस लॉ से स्टार्ट करेंगे, TT एंथनी and versus State of Kerala and others. It was held that information given under subsection 1 of section 154 of Criminal Procedure Code, commonly known as FIR, though this term is not used in the code and its nickname suggests, it is earliest and the first information of the cognizable offence recorded by an officer in charge of a police station. तो generally कौन रिकॉर्ड करता है? ऑफिसर इन चार्ज ऑफ अ पुलिस स्टेशन। Section 154, every information in cognizable offences, every information relating to the commission of a cognizable offence, again cognizable offence कहाँ defined है? 2C definition clause of criminal procedure code, if given orally to an officer in charge of a police station, shall be reduced to writing by him or under his direction and be read over to the informant, and every such information, whether given in writing or reduced to writing as aforesaid, shall be signed by the person giving it, and the substance thereof shall be entered into a book to be kept by the officer in such form as the state government may prescribe in this behalf। बेसिकली जो FIR है ये ऑरली, ये इन्फॉर्मेशन डिस्क्लोज आप कर सकते हो ऑरली एज वेल या इन राइटिंग, बट जस्ट इन केस आपने ऑरली कोई कंप्लेन के बारे में, कोई कंप्लेन योर और यू हैव information you're disclosing before the court or before the police station, I'm so sorry, before the officer in charge of a police station, so that shall be taken in writing। वो हमेशा राइटिंग में होता है FIR। एंड FIR का एक नीचे वाला जो वंस द FIR हैज़ एंडेड, उसके नीचे यू आर ऑलवेज मेड टू साइन, इफ़ यू आर द पर्सन हु इज़ अ विक्टिम और जिसके साथ कुछ हुआ है, देन यू आर मेड टू साइन दैट। एंड जो FIR है उसकी फ्री ऑफ कॉस्ट कॉपी आपको दी जाती है। दीज आर सम मैंडेटरी प्रोविजंस। व्हेन आई से मैंडेटरी मीन्स द पुलिस ऑफिसर और द ऑफिसर इन चार्ज ऑफ अ पुलिस स्टेशन हैज़ टू डू इट। provided that if the information is given by a woman against whom an offence under 326, 326b, 354, 354a, 354b, c, d, 376, 376a, b, c, d, e, or 509 of the IPC are alleged to have been committed or attempted, then such information shall be recorded by a police woman officer or any woman officer. अगर अब कोई ऐसा offence है with जो इन सारे sections में which has been done against a woman under these sections, then such disclosure of the offence against that woman shall, please focus on the word shall, be recorded by a woman police officer या कोई woman officer. Provided that in the event that the person against whom an offence under 354 to D, ABCD, 376 to 376E or 509 of IPC is alleged to have been committed or attempted, is temporarily or permanently mentally or physically disabled, then such information shall be reduced by the police officer at the residence of the person seeking to report such offence or at a convenient place of such person choice, in the presence of an interpreter or a special educator as the case may be, just in case that person is या तो mentally or physically permanently या temporarily disabled है, so the informant does not have to come to the police. What the police has to do is they have to go to the informant. और जो if there is a disclosure with respect to these offences जो दिए गए हैं 323, 376 या 509 of IPC में, then जो ये information है it shall be videographed. ठीक है, तो police officer shall get the statement of the person recorded by a judicial magistrate under clause A of subsection 5A of section 164 as soon as possible. A copy of the information as recorded under subsection 1 shall be forthwith given free of cost to the informant. कभी कभी ये पूछा जाता है कि ये कभी कभी नहीं, I have seen a lot of MCQs with respect to this subsection कि बताइए जी whether it is to be given free of cost or not, या FIR के कुछ mandatory essentials लिखे होंगे and the question would be like pick the odd one out. जैसे दिया गया होगा FIR copy to be given free of cost, ये एक, या that it is to be read over to the informant, yeah, it is to be signed by the informant, and then one of the essentials जो नहीं होगा वो दिया होगा and you have to pick the odd one out. Then subsection 3, any person aggrieved by the refusal on part of an officer in charge of a police station to record the information referred in subsection 1 may send the substance of such information in writing and by post to the superintendent concerned, who is satisfied that such information discloses the commission of the cognizable offence, shall either investigate the case himself or direct an investigation to be made by police officer subordinate to him in the manner provided by the case provided by this code, and such officer shall have all the powers of an officer in charge of a police station in relation to that offence. अगर आप for example you go to police and police is like नहीं जी FIR तो register नहीं करेंगे, does that mean that your remedy is extinguished there? The answer is no. आप superintendent of police, you will write an application disclosing what the offence against you has been done and send it via post. आप via post भेजोगे and जो superintendent of police है या तो वो खुद investigate करेंगे, he will either himself investigate or direct any police officer to investigate the matter. और जो ये any police officer है, not necessarily कि वो officer in charge of a police station होगा, but while he is investigating the matter, then he will have all the powers of the officer in charge of a police station while he is investigating the matter. Then we have section 155. We'll discuss this tomorrow. आज हम section 154 के case laws पढ़ेंगे. There is another question that came before the Honorable Supreme Court, whether it is mandatory to register an FIR or not. There is a landmark case, ये बहुत बार पूछा जाता है, ललिता कुमारी versus State Government of UP. It's a very very important case law, जहाँ पे this question was answered by the Honorable Supreme Court. The question whether it's obligatory for the police to register FIR on information given by the informant has been answered in affirmative by 5-member bench in the above titled case. The Supreme Court held that the provisions of 154(1) CrPC is mandatory and the officer concerned is duty bound to register the case on the basis of information disclosing commission of cognizable offence. It is mandatory provision. If no cognizable offence is made out in the information given, then the FIR need not be registered immediately. अगर अब cognizable offence disclose हो रहा है, for example murder, ठीक है, and I was a witness to that murder, मैंने देखा कि X person ने Y person का murder कर दिया, मैं चली गई पुलिस के पास कि भाई FIR रजिस्टर कर दो, ऐसे ऐसे हुआ है. पुलिस, what the Supreme Court has held is that police is duty bound. It is mandatory कि वो मेरा जो FIR है immediately record करे, my information that I am stating वो immediately record करे, ठीक है. But if it's a non-cognizable offence, तो it's not mandatory in such a situation कि immediately register हो the information that has been provided to the police officer. Then in another case, State of Haryana versus Bhajan Lal, Supreme Court held that information given under 154 is not qualified by the term reasonable by omitting the words reasonable or credible. The intent of the legislature is clear that it is meant to encompass every information. अगर आप सेक्शन 41 याद करोगे, हमने उसमें पढ़ा था, हम जब भी इंफॉर्मेशन टर्म वहाँ यूज हुआ है, the word that has preceded information is reasonable या credible. The reason being कि if you have to arrest a person without a warrant, जो वो information है वो reasonable होनी चाहिए. ऐसे नहीं कि आपका मन किया और आप उठे और आपने किसी को भी arrest किया, ध्यान, वो तो that is not allowed. But in case of section 154, the fact that information has अकेले से भी अकेले word use हुआ है, अकेले से use हुआ है, the reason is that the legislature intended it to be like that. That is because when there is a disclosure of any cognizable offence, then it is mandatory upon the police कि वो FIR register करे. ज़रूरी नहीं है कि police वो information reasonable हो या credible हो. That is not important. Okay. Now evidentiary value of FIR, ये question काफ़ी पूछा जाता है MCQs में, whether FIR is a substantive piece of evidence, whether it's a corroborative piece of evidence. So we will be studying about that here. FIR is not a substantive piece of evidence. ये एक substantive piece of evidence नहीं है. That is, it is not evidence of facts which it mentions. अगर आपने डिस्क्लोज कर दिया FIR में कि X ने Y का मर्डर कर दिया, ये सिर्फ एक इंफॉर्मेशन है, ठीक है, इट इज जस्ट एन इंफॉर्मेशन. द फैक्ट दैट द FIR हैज बीन रजिस्टर्ड डज नॉट वैलिडेट द फैक्ट्स. इसका मतलब ये नहीं है कि जो फैक्ट्स आप डिस्क्लोज कर रहे हो बिफोर द ऑफिसर इन चार्ज ऑफ अ पुलिस स्टेशन वो 100% वैलिड हो या वो 100% ठीक हो. FIR can be used to corroborate the informant under section 157 of the Indian Evidence Act or contradict him under 145. अब देखिए, FIR रजिस्टर होने के बाद one thing that is important to be noted is कि आप पुलिस के पास जाते हो FIR रजिस्टर करवाने, उससे क्या होगा, जो पुलिस मशीनरी है that will be set into motion and the investigation will start. Once the investigation has started, एक particular statutory period में क्या होगा, the चालान will be filed या charge sheet will be filed. तो once the charge sheet has been filed, the trial will begin. Trial begin होने के बाद दो चीज़ें होंगी, या तो accused को सज़ा लगेगी या वो discharge होगा, ठीक है. These two things will happen. Either he'll be held guilty or he will be discharged. But while the trial is commencing, जो ये FIR है, इसके बाद जो investigation start हुई है, investigation में पुलिस क्या करती है, then they kind of tend to see कि कौन था कौन नहीं था. 161 में भी statements record होते हैं, 164 में भी statements record होते हैं, और हमारे पास होता है FIR charge sheet में, ठीक है, and the other evidence that they have collected. Now once a person who is a witness, he is brought before the honorable court, और उसको ट्रायल में फॉर एग्जांपल उसने देखा है, जैसे मैं इन्फॉर्मेंट हूँ तो मुझे एक पुलिस के सामने कोर्ट ऑनरेबल कोर्ट के सामने लाया. 161 is the statement you give before the police. 164 is the statement you give before the magistrate and FIR. Now, all these three statements of 161, 164 and FIR will be used by the defense counsel as well as the prosecution का जो वकील होगा or the prosecution. They will use these in order to do what? To either corroborate या contradict. कई बार ऐसा होता है कि नहीं होता याद कि आपने 161 में क्या बोला, 161 में आपने कुछ ऐसा स्टेटमेंट बोल दिया जो बिल्कुल कॉन्ट्रडिक्ट किया 164 के. फिर जब आपका एग्जामिनेशन हो रहा है, क्रॉस एग्जामिनेशन हो रहा है या एग्जामिनेशन इन चीफ हो रहा है, आप बिल्कुल कॉन्ट्रडिक्टरी बोल देते हो. ठीक है, तो आपने जो ये स्टेटमेंट्स ऑलरेडी दिए हैं या जिस पे FIR बेस्ड है, उसकी तो वैलिडिटी या हाउ बिलीवेबल दैट इज वो काफ़ी रिड्यूस हो जाता है. ठीक है, दैट इज वाई हियर इट इज सेड दैट FIR कैन बी यूज्ड to corroborate the informant under section 157. 157 of the Indian Evidence Act is former statements of the witness may be proved to corroborate later testimony as to the same fact. ठीक है, या फिर उसको आप कॉन्ट्रडिक्ट करवा सकते हो वो स्टेटमेंट, या आप वो स्टेटमेंट उससे प्रूफ भी करवा सकते हो. मे बी ही कैन गिव से एग्जैक्टली व्हाट इज टू बी said. Then 145 is cross-examination as to previous statements in writing is 145. So basically you can either corroborate under 157 or cross-examine the particular person or an informant. In Agno-Nagatia versus State of Bihar, it was held that in view of section 145 of Indian Evidence Act, FIR can be used for cross-examination of the informant and for contradicting him. Considering section 157 and 145 of the Indian Evidence Act, it can be deduced that FIR cannot be used for the purpose of corroborating or contradicting any witness other than the one registering the FIR. Then, even though the FIR is only hearsay and does not have to be submitted by someone who has a first-hand knowledge of the facts of the case, it serves as a foundation upon which the entire investigation and prosecution will be conducted. The FIR is thought to have higher evidential value than any of the statements made by the police over in the course of an inquiry. Just a second, I'm so sorry. Yes. In the course of inquiry, if the accused files the FIR himself, the following options are available. अगर accused ने, ऐसा भी हो सकता है, the accused can file an FIR himself, then it will fall either into either of these categories, either a confessional FIR or a non-confessional FIR. If the FIR is confessional in nature, then section 25 of the Indian Evidence Act prevents it from being utilized against the accused या informant. अब section 25 of the Indian Evidence Act किस चीज़ से डील करता है? It says that confession to police officer not to be proved. No confession made to a police officer shall be proved as against the person accused of any offense. ठीक है, तो confessional FIR में it prevents the statement that he is giving before the police to be used against him. Non-confessional FIR may be a non-confessional FIR may be admitted in evidence under section 21 of the Indian Evidence Act or for the purpose of demonstrating his behavior under section 8 या 32 subsection 1 or 21 of the Indian Evidence Act. Now a question that has come before the Honorable Supreme Court in various case laws is कि अगर आपने telephonic conversation, for example you have made a call disclosing the commission of an offence, उस basis पे FIR register हो सकता है क्या? The answer is yes. The Honorable Supreme Court held in Siddhartha Vashisht Manush Sharma versus NCT of Delhi held that phone calls may be immediately after the incident to the police constitutes an FIR only when they are not vague and cryptic. So the condition is they do not have to be vague and cryptic. Calls purely for the reason of getting the police to the scene of crime do not constitute the FIR. आपने पुलिस को बोला वही इधर आ जाओ, that does not mean that that's an FIR. Now, delay in lodging an FIR. There is no time limit set by the government or the courts for reporting the crime to the police. However, it has been recognized that an FIR must be filed in a timely manner. The issue of reasonable time is a matter for the court to decide the case. As a result, a simple delay in filing the FIR with the police is not always fatal to the prosecution. Generally recommended है कि आप you do it in due course of time, but case to case vary करता है. For example, some person has been in captivity, ठीक है, maybe that person was scared कि उसको धमकाया जा रहा था कि don't lodge an FIR, पुलिस के पास मत जाना. Is it reasonable that just because उसके साथ कुछ time पहले the offenses happened and now that he's out, so he cannot come before the police disclosing what has happened against him? The answer is absolutely no. जस्ट इन केस केस टू केस बेसिस पे डिसाइड होगा. एंड कहीं कहीं पे जैसे रेप केसेस हैं, देयर आल्सो द सुप्रीम कोर्ट एंड कोर्ट्स का अप्रोच ऐसा रहा है दैट दे हैव हेल्ड कि बिकॉज offenses like this are, you know, prestige and reputation, they kind of, you know, damage that, which shouldn't be the case, but unfortunately it is. So in situations mein you cannot say that since there has been a delay in registration of FIR cannot be registered. The Supreme Court noted in the case of State of Rajasthan versus Om Prakash that the FIR was lodged about 26 hours late. However, because the case concerned rape of a juvenile and reputation and prestige of the family as well as the career and life of a young adult, this did not impair the prosecution case. Then State of Maharashtra versus Joseph Minghal Kohli. The answer to the question whether FIR in a given case has been lodged belatedly or not is not always a question of fact. तो ये हमेशा question of fact नहीं होता, and has to be answered bearing in mind the facts of the case in question and also the explanation furnished by the prosecution in case where there is some delay in it being lodged. What the court has to do is examine करना है कोर्ट को. क्या करना है? examine whether the delay is inordinate. कि आप अब आपके साथ offense, for example कोई cognizable offense हो गया 10 साल पहले, and suddenly you feel like after 10-20 years you feel like I want to come before the court और मुझे बोलना है कि मेरे साथ 10 साल पहले ये हुआ था. तो in that case the court will consider कि whether the delay that has happened in a particular case कि वो inordinate था, क्या कोई is there a cogent explanation, कोई reasonable explanation as to why there was so much delay in lodging the FIR, and courts will consider that. Refusal to lodge FIRs. अब आपके पास दो remedies है, statutory remedy और judicial remedies. Statutory remedy ये है that if an officer in charge of a police station refuse कर रहा है आपका FIR register करना, तो आप क्या करेंगे? Under section 154 subsection 3 you can by post write to the superintendent of police, और वो superintendent of police will either investigate the matter himself or delegate the same upon any other police officer. What is the judicial remedy? If the remedy provided under section 153 subsection 3 fails to work, अब आपको superintendent of police ने भी बोला कि भाई हम तो नहीं करेंगे, then what option do you have? The informant should submit a private complaint with the competent judicial magistrate under section 156(3) read with section 190 of the Criminal Procedure Code. On receiving such a complaint, the magistrate is entitled to take notice of the case and order the police to investigate it. बहुत बार ऐसा होता है, आपने you have disclosed the commission of an offence before the officer in charge of a police station. उसने नाम बोल दिया. The superintendent of has also said that नहीं हम तो नहीं register करेंगे. So what we generally do in courts is हम ये दोनों complaints लेते हैं, ये जो particular complaint है, you submit it before the honorable magistrate under 156 subsection 3 and you make it as an annexure. आप जज को ये दिखाओगे and judges ask for it कि आप गए थे पुलिस के पास, आप गए थे superintendent of police के पास, you make them as an annexure and which is a photocopy of the complaint. आप उसको annexure बना के you will show it to the honorable court कि देखिए हम तो गए थे but they refused to register a FIR, and when the court takes cognizance of what has happened to you, वो या अगर अब prima facie disclose हो रहा है कि आपके साथ offense हुआ है कि you have, you know, something has happened with you, then in such case the magistrate takes the cognizance, या the magistrate can also direct कि भाई और investigate करो. There needs to be further investigation. Now there is a question जो मैं सोच रही थी मैं slide बनाऊँ, and now that I have concluded this, मुझे अब दिमाग में आ रहा है कि I haven't done that, पता नहीं क्यों, but I will still discuss that in this particular lecture. That is, what is the difference between an FIR and a police complaint? एक police complaint और FIR में क्या difference है, ठीक है? तो जो FIR है, it relates to disclosure of cognizable offense, और जो police complaint है, it is only with respect to cognizable offense. Police complaint can be either both in cognizable offenses or non-cognizable offenses. Number one difference. Number two, FIR जो है, it is given to the police officer in charge of a police station. और जो आप police complaint है, ये आप किसको देते हो? Generally to a magistrate. आप ये देते हो magistrate को. This was one question that I had in my mind. Another thing, जो सबसे ज़्यादा ये question पूछा जाता है, which I have seen in MCQs, मैंने आपको इससे पहले भी बोला, is that whether it's mandatory to provide the FIR copy to the informant or not. Yes, informant को तो मिलेगा ही मिलेगा, but जो accused है उसको भी free of cost उसको दी जाती है the copy of the FIR. ये दिया गया है हमारे सेक्शन 207 ऑफ क्रिमिनल प्रोसीजर कोड में कि उसको भी फ्री ऑफ कॉस्ट आप FIR की कॉपी दोगे, ठीक है? तो FIR का हम क्विकली रिविजन करते हैं कि आज के लेक्चर में हमने क्या पढ़ा. 154 डील्स with FIR, first information report. It is the first information with respect to the commission of any cognizable offense, ठीक है? Now under the essential elements of an FIR जो है, that it must relate to the disclosure of any cognizable offense. It should be given either written या orally, ठीक है? Orally, and जहाँ पे orally है, then the police officer in charge of a police station, he shall, the word used is shall, he will take it down in writing, he will read over the FIR or the disclosure of information before the informant, और वो डेली डायरी में नोट लिखेंगे कि भाई आज टुडे भी बेसिकली दे विल टेक अ नोट ऑफ इट, ठीक है? अब क्या होगा? वंस द FIR हैज बीन लॉन्च, द पुलिस विल इन्वेस्टिगेट द मैटर. वो एविडेंसेस कलेक्ट करेंगे, वो स्टेटमेंट्स रिकॉर्ड करेंगे ऑफ द पीपल हु विल बी द प्रोसिक्यूशन विटनेसेस, ठीक है? और वो किसी पर्सन को अरेस्ट भी कर सकते हैं. अगर अब रिफ्यूजल हुआ टू रजिस्टर एन FIR, तो आप पहले सुपरिंटेंडेंट पुलिस के पास जाओगे, उसके बाद मैजिस्ट्रेट के पास जाओगे, ठीक है? Also, what is the evidentiary value of an FIR? It is not a substantial piece of evidence, but it is a corroborative piece of evidence, ठीक है? Then we have one more important thing जो मैं आपको which I forgot to discuss with you, कि what is zero FIR? Zero FIR कभी कभी पूछा जाता है. Zero FIR simple, offenses happened at X place and the FIR has been registered at Y place. This is basically the crux of what a zero FIR means, ठीक है? I hope आज के lecture में I have been able to make you understand what FIR is, and मैंने case laws भी, अगर आप इतना ही लिखोगे, and this is all you study and these are the notes you take, if you are taking notes at all, this is more than enough for any exam, be it prelims or mains, with case laws and fair provision. I hope आपकी सारे doubts clear हुए होंगे, and if there's any other question for me or if you have any other doubt, please drop me an email या comment section में मुझे बता दीजिए. See you next time with another lecture. Bye bye.